In Oklahoma, the Brady Doctrine, mandating that the prosecution disclose all exculpatory evidence to the defense, is not just an obligation but a constitutional guarantee under the Fifth, Sixth, and 14th Amendments. Yet, the state's approach to this critical mandate, particularly in relation to law enforcement misconduct, is not just negligent, it's outright defiant. Oklahoma's refusal to adopt the Brady List, a tool designed to keep track of officers with a history of misconduct, stands as a glaring failure to ensure fair trials. This refusal is not only an affront to the principles of justice, but a systemic failure that jeopardizes the integrity of the entire criminal legal system. In Oklahoma, Brady disclosures are handled with an alarming degree of inconsistency and opacity. While the doctrine demands transparency, the state has instead shrouded law enforcement records in secrecy. This lack of compliance is not just theoretical. It's manifesting in real, high-profile cases like that of Richard Glossip. In the Richard Glossip capital murder case, which is now before SCOTUS, ADA Connie Smotherman parlayed her prosecutorial misconduct into a law professorship at Oklahoma City University School of Law, while ADA Fern Smith continues to rewrite the rules of justice, one unethical prosecution at a time in Johnston County, Oklahoma. His ongoing legal battle illustrates the dire consequences of suppressed evidence, and he's not alone. Gabriel Arce and Funk versus Green further underscore how the state's intentional misrepresentations and failure to disclose critical information turns fair trials into a mere illusion. This systemic failure is not an accident. It's the result of deliberate inaction by those in power. Let's break down the key players who could, but don't, ensure that Oklahoma upholds its constitutional obligations. Governor Kevin Stitt seems to prefer surprises, just not the kind that guarantees a fair trial. Keeping Oklahoma Brady non-compliant ensures the state stays in the dark ages of justice, where transparency is treated like an optional upgrade. What has Governor Stitt done to ensure fair trials? Very little, if anything. His administration has shown no urgency in adopting the Brady List or in pushing for statewide reforms to ensure that exculpatory evidence is consistently and transparently disclosed. The governor could advocate for legislative changes that would mandate such disclosures, yet he remains silent, leaving Oklahoma's justice system stuck in an era of secrecy and surprise verdicts. Attorney General Gentner Drummond seems to think that withholding evidence is a winning strategy. After all, you can't lose a game if the other team never sees the rule book. Despite his position as the state's top legal officer, there has been no significant movement from AG Drummond's office to rectify the state's failure to meet Brady obligations. His office could institute mandatory policies for prosecutors across the state to ensure compliance, but instead, it seems content with the status quo, where fair trials are more a matter of luck than law. Chief Justice John Kane seems to think justice is best served with a side of secrecy, because nothing says fair trial like keeping the truth under wraps. The Oklahoma Supreme Court, under his leadership, has failed to enforce the stringent requirements of the Brady Doctrine. The court could use its authority to ensure lower courts rigorously enforce Brady obligations, yet it has not taken the necessary steps to address the systemic issues plaguing the state's legal system. Secretary of State Brian Bingman seems to believe that transparency is overrated, because why let the truth shine through when you can keep the legal system comfortably opaque? While not directly responsible for law enforcement oversight, Secretary Bingman could use his platform to advocate for greater transparency in government operations, including the justice system. However, his office has remained passive, missing an opportunity to push for reforms that could protect citizens' rights. Derry Stacey's CLEAT, Council on Law Enforcement Education and Training, might teach law enforcement how to enforce the law, but keeping Brady compliance on the back burner ensures there's always a get out of accountability card in the deck. CLEAT could require that all officers' disciplinary records be made available for Brady disclosures, but instead, it has chosen to prioritize officer protection over public transparency. Janet K. Johnson, head of the Oklahoma Bar Association, might run the bar, but it seems she prefers lawyers to have a few tricks up their sleeves, like keeping Brady disclosures in the Do Not Open file. The bar could sanction attorneys who fail to meet Brady obligations, yet it has done little to hold prosecutors accountable, allowing unethical practices to continue unchecked. Let us not forget the role of law enforcement unions and associations with their uncanny ability to get legislation passed. With law enforcement unions like the Oklahoma Fraternal Order of Police, Oklahoma Sheriff's Association, and the Oklahoma State Troopers Foundation, funded by civil forfeiture and infraction fines and fees, it's like they're enforcing the law with one hand and pocketing the profits with the other. It has gotten so bad that 68 out of 77 Oklahoma sheriffs are named in a RICO case for allegedly running an extortion racket. It's obviously less about law and order and more like a statewide shakedown. Looks like Oklahoma justice isn't just blind, it's for sale. Oklahoma is not currently in compliance with its Brady obligations. The refusal to adopt the Brady List and ensure proactive disclosures of law enforcement misconduct leaves the state vulnerable to legal challenges and undermines the very foundation of fair trials and due process. Cases like Richard Glossip, Gabriel Arce, and Funk versus Green highlight the urgent need for reform. Without action, the state risks costly remedies that will burden taxpayers and continue to erode trust in the justice system. The Brady List could dramatically assist the state in reaching compliance, ensuring that justice is served with integrity. The failure to be in compliance with Brady obligations not only costs the state its moral standing, but could also lead to financial consequences, as wrongful convictions are overturned and lawsuits are filed. As it stands, Oklahoma's approach to Brady is less about justice and more about maintaining a system where the truth is optional and accountability is avoided at all costs.